The Attorney General's Chambers stands at the heart of government decision-making. Every opinion we render, every case we defend, and every word we advise carries weight, not just in law, but in public trust. Within that framework, the Civil Litigation Division carries a distinct responsibility to robustly defend the Turks and Caicos Islands government in court, but equally to draw from those experiences the lessons that strengthen decision-making and enhance the overall quality of governance. Each matter, win or lose, teaches us something about process, preparation, and the importance of acting with fairness and foresight. Those lessons don't end in the courtroom. They become tools for building a stronger, more accountable public service. And so today, I am proud to introduce the Civil Litigation Brief Beyond the Courtroom, a new podcast series developed by Principal Crown Counsel Clemma Hippolyte and her competent and highly commendable civil litigation team. This series is more than commentary on legal matters. It is a conversation where members of the Civil Litigation Division unpack the challenges and triumphs of defending the government and translate those experiences into insights for public officers, boards, and policymakers across the Turks and Caicos Islands public sector. Because the truth is, litigation is not only about the courtroom, it's about every decision made before a matter ever reaches there. It's about how we respond, how we prepare, and how we lead. The Civil Litigation Brief Beyond the Courtroom opens that window. It's an inside look at what it takes to manage risk, prevent litigation, and to transform those experiences into lessons that inform, inspire, and ultimately shape a more resilient and accountable public service. So I invite you to listen closely, to hear the voices behind the advocacy, to discover the lessons behind the law. Tune in, learn, and be part of the conversation.
Welcome to the Civil Litigation Brief. I am your host, Aja Rickby. Today's episode is closely linked to the Civil Litigation Training Seminar and the broader Civil Litigation Blueprint Initiative. Today's discussion is particularly directed to permanent secretaries, heads of departments, senior managers, board and tribunal members, because civil litigation risk is created and managed at a leadership level. We will explore what civil litigation risk is, how it arises, and why early engagement, consultation, and disciplined decision-making matters. I am joined by the esteemed Honorable Attorney General, Mrs. Rondalee Brathwaite Knowles, KC, who will share why this training is critical for those particularly in decision-making across government. Honorable Attorney General, welcome to the Civil Litigation Brief. How are you today?
I'm fine, Aja. Thank you. I'm very pleased to be here.
I'm very pleased to have you here, Honorable Attorney General. So, Honorable AG, why is litigation risk something that senior public officers, particularly permanent secretaries and heads of departments, must understand personally?
Thank you, Aja. Excellent question. Because litigation risk is not generated in chambers. It is generated at the point of policy formulation and administrative decision-making. Permanent secretaries and heads of department are often the architects of those decisions. The 2-day seminar is important because it places decision makers in direct conversation with legal risk, how it arises, how courts assess it, and how it can be avoided. This is not theoretical. It speaks to daily governance and personal accountability.
Thank you, Honorable AG, for that answer. And it links directly to the second segment, early referrals and the seminar's purpose. We mentioned the civil litigation seminar. Day one of the seminar focuses heavily on early referrals and record keeping. Can you tell us why is that emphasis deliberate?
It's deliberate because late referral is one of the most persistent and avoidable sources of litigation exposure across government. When matters reach chambers after decisions have already been finalized or implemented, the legal terrain has often shifted beyond repair.
Yeah.
At that point, the issue is no longer how to ensure legality, but how to defend a decision that may already be vulnerable. From a judicial review perspective, courts scrutinize decisions through well established principles: lawfulness, procedural fairness, rationality, and proportionality.
Mm.
Early referral allows chambers to engage at the stage where those principles can meaningfully shape the decision making process. We can advise on whether the decision maker has acted within statutory authority, whether affected persons ought to be consulted, whether relevant considerations have been taken into account and irrelevant ones excluded, and whether the outcome is proportionate to the objective being pursued. Once a decision has been taken without that analysis, those defects cannot be cured retrospectively. Courts do not permit public authorities to reconstruct reasons or justify outcomes after the fact. They look to contemporaneous records and lawful process. That is why record keeping is inseparable from early referral. It is the evidential foundation upon which decisions are assessed in judicial review. The seminar is therefore designed to reposition legal advice as part of the architecture of good governance and not as a defensive exercise. Permanent secretaries and heads of department are critical because judicial review ultimately examines decisions at the level at which they are authorized. Embedding an understanding of these principles at the leadership level is essential if government is to reduce avoidable legal exposure and maintain credibility before the courts.
Thank you for that answer, Honorable Attorney General. And we will move on to consultation and legislative risk. Honorable Attorney General, the training also addresses consultation, particularly in relation to legislation. Why is this a key focus?
That's an excellent question. Because legislation that adversely impacts an identifiable segment of the population is especially vulnerable to challenge where consultation has been overlooked, superficial, or treated as a mere formality. In such cases, courts do not approach the issue in the abstract. They examine whether government has acted consistently with constitutional principles of equality, fairness, and the rule of law, particularly where the burden of a legislative measure falls disproportionately on a defined group. Day two of the seminar examines how courts assess fairness proportionality, and meaningful participation in the legislative process. Where legislation interferes with rights, benefits, or legitimate expectations, the absence of consultation may amount to procedural unfairness or a failure that takes relevant considerations into account. In some cases, it may also engage equality principles where affected groups are treated differently without adequate justification. Senior officers must therefore understand that consultation is not a courtesy nor a matter of political optics. It is often a constitutional safeguard that underpins the legitimacy of legislative action. Proper consultation demonstrates that government has acted lawfully, rationally, and with due regard to those affected. Where the discipline is absent, legislation is far more vulnerable to constitutional and public law challenge, exposing government to legal, reputational, and institutional risks.
Thank you, Honorable AG, for that answer. So, permanent secretaries and senior managers should get ahead of the problem instead of waiting.
That's right.
Got you. We will now move on to segment 4, post-judgment obligations. Another theme of the seminar is compliance with the court orders and post-judgment directives. Why is this so important?
It's very important because litigation risk does not end with judgment. Delay or resistance in implementing court orders exposes the government to contempt, adverse costs, and reputational harm. The seminar is intended to make clear that once the court has spoken, compliance is a matter of constitutional obligation. Senior leadership must understand this because post-judgment decisions often sit squarely with permanent secretaries and heads of department.
Thank you for that answer, Honorable AG. So after a post-judgment, senior permanent secretaries and heads of department should implement whatever the judgment is to avoid legal risk.
That's correct.
Thank you. We will now move on to segment 5, why attendance matters. What would you say to those questioning whether this seminar is necessary for senior officers?
Oh, I would say that litigation preparedness is not delegable. Those who authorize decisions must understand the legal consequences of those decisions. The 2-day seminar is not a legal technical exercise. It is a leadership forum. Attendance by permanent secretaries, heads of department, and senior managers is essential because it is at that level that litigation risk is either mitigated or created.
Thank you, Honorable Attorney General. This has been a very informative session. Any final messages before we approach the seminar?
This training is an investment in better governance. Early referral, meaningful consultation, disciplined records, and lawful compliance are not burdens, they are protections. I strongly encourage senior officers to engage fully over the 2 days of training. The lessons learned here will shape not only litigation outcomes, but credibility and effectiveness of government decision-making more broadly.
Thank you, Honorable Attorney General. This is the Civil Litigation Brief. As we head into the 2-day Civil Litigation Training Seminar, the message is clear. Litigation risk begins with leadership, and so does its solution.